All right, should we get started?
I think we can go ahead and get started.
Great. Good evening. The Town of Los Gatos Planning Commission meeting of Wednesday, June 23, 2021 is now called to order. This meeting is being conducted using teleconferencing and electronic means consistent with the State of California Executive Order N29-20 dated March 17, 2020 regarding the COVID-19 pandemic. The live stream of the meeting may be viewed on Comcast Channel 15 and/or online as noted on the agenda. In accordance with the order, the public may only view the meeting on television or online and not in the council chambers. We are conducting tonight's meeting in a virtual setting using Zoom. All planning commissioners and staff are participating from remote locations, and all voting will be conducted by roll call vote. Director Paulson, would you please call the roll?
Yes, thank you. Commissioner Thomas,
Present.
Commissioner Suzuki,
Here.
Commissioner Barnett,
Present.
Chair Janoff.
Present.
Let the record reflect that Commissioner Birch, Tavana, and Hanson are not with us this evening. Thank you.
All right, thank you. As the Planning Commission conducts this meeting on behalf of the Town Council and the residents of Los Gatos, we encourage active participation, which is essential for the democracy and critical to the work of the Planning Commission. That participation can occur through written comments about agenda items submitted to a staff prior to a meeting. They are always welcome and helpful. During our meeting, there are two opportunities for members of the public to participate. During the verbal communications period, an individual may speak on a topic not on the agenda. And during the hearing on a specific agenda item, a member of the public may speak about that item which is on the agenda. If you wish to address the commission tonight during verbal communication or during the consideration of the agenda item, you must join the Zoom webinar via the link and password provided on page 2 of the staff report. When I announce the item for which you wish to speak, please click the raise hand feature in Zoom. If you are participating by phone, press *9 on your telephone keypad. When called to speak, please state your name and address for the record. Alternatively, you may choose to speak anonymously, and it is requested that you limit your comments to 3 minutes. We've now come to the verbal communications portion of our meeting. Members of the public are invited to address the commission on any item not on the agenda. Dr. Paulson, do we have any members of the public wishing to speak at this time?
Thank you, Chair Janoff. We'll give it a second. I don't see any hands raised for items not on the agenda. I think we can move forward.
All right, thank you. The next item on the agenda is the consent calendar, and tonight we have 2 consent items to be acted upon in a single motion. First is the draft minutes of the June 9th, 2021 Planning Commission meeting. And second is to continue to August 11th, 2021, the adoption of amendments to consideration of the adoption to amendments to Chapter 29, Article 1, Division 2, zoning regulations regarding tree protection of the town code. It has been determined that there is no possibility that this project will have significant impact on the environment. Therefore, the project is not subject to the California Environmental Quality Act section in the town of Los Gatos. And it is being requested that this be moved to a future date in order for the material to be prepared. Does any commission member or member of the public wish to pull either item from the consent calendar? I don't see any hands raised. And so with that, may I have a motion for approval of the consent calendar? Commissioner Barnett.
I'll move to approve the consent calendar.
Thank you. And do I have a second?
Second.
Thank you, Commissioner Thomas. And now we'll take a roll call vote. Commissioner Barnett,
Yes.
Commissioner Thomas,
Yes.
Commissioner Suzuki,
Yes.
and I vote yes as well. So the consent calendar passes. We're now moving on to the public hearing, which is agenda item 3. And this is to provide the public with an opportunity to give verbal comments on the draft environmental impact report for a request for planned development for a senior living community on property zoned RPD located at 110 Wood Road, APN 510-47038. It should be noted that no action will be taken at this meeting. property owner, Covia Communities, applicant, Rockwood Pacific, and project planner, Sean Mullen. I understand, Mr. Mullen, you'll be giving us a staff report tonight.
Thank you and good evening. As mentioned, a draft environmental impact report has been prepared for the proposed plan development for a senior living community at 110 Wood Road. As required by the California Environmental Quality Act, this public hearing is being held during the 45-day public review period for the draft EIR. This public hearing is an opportunity for members of the public to provide verbal comments on the completeness and adequacy of the draft EIR. This public hearing is not intended for consideration of the proposed project, nor for the actual certification of the draft EIR. No action will be taken at this meeting. A Planning Commission hearing for consideration of the final environmental impact report and the proposed project has not been scheduled at this time. The Town Council is the deciding body for the proposed project. This completes staff's presentation, and I'm available for any questions.
Thank you, Mr. Mullen. Do any commissioners have questions for staff? I don't see any hands raised. And yes, just as a reminder to the planning commissioners and to the public, the purpose of this meeting is to receive public comments on this item. And so this opportunity for the planning commissioners to hear those comments. And then, as Mr. Mullen stated, we will be hearing the full application at a later date with the final EIR. In addition, I wanted to remind commissioners that our other business item on the agenda is a brief training session on CEQA. So if you have any general questions about CEQA, please hold them until we get to that portion. If you have any specific questions regarding tonight's matter, then there'll be an opportunity to ask those shortly. All right, having said that, we'll now open the public hearing and give the applicant up to 5 minutes to address the commission.
So thank you, Chair. Actually, since this is strictly to receive public comment, the applicant does not make a presentation, so we'll go straight to verbal comments that folks would like to add.
All right, thank you for that. So at this time, members of the public may choose to speak. And when you do, please state your name and address, or you may choose to speak anonymously, as I mentioned before, but please understand that this meeting is being recorded for the public record. Director Paulson, do we have any members of the public who would like to speak at this time?
Thank you, Chair Janoff. I don't see any hands raised. I'm going to give it a couple seconds here. No hands are raised, Chair Janoff.
All right, thank you. So given that there's no applicant in this case, we have no comments, then I'll close the public portion of the meeting. And do we move on to other business or inquire as to whether there are questions?
You can see if there are questions, but most of them probably would be general questions. As stated in the staff report, we wouldn't respond to comments had any been provided. Folks do have an opportunity to continue to submit comments in writing for those who want to provide verbal comments. We often don't get a whole lot of verbal comments at these hearings. Most people choose to do that in writing. And Mr. Mullen, if you can just remind us in the audience the date by which those written comments need to be submitted.
Yes, the deadline at the end of the 45-day review period is 5 p.m. on July 12th, and written comments can be submitted through the contact information provided.
All right, thank you for that. So unless there are questions, then we will move on to other business tonight. And in association with the DEIR and then the upcoming EIR that the Planning Commission will review, we ask staff to provide an overall guidance to the Planning Commission, particularly since we have new members of the Commission, just talking about CEQA and what the EIR is, its purpose, and our role in reviewing and ultimately recommending it go forward or not. And so with that, I think we are turning it over to the town attorney, Mr. Schultz, is that correct?
Actually, I'll go ahead and present. Thank you, Chair Janoff. I gave a very brief overview at the last meeting, understanding that this meeting to accept verbal comments on 110 Wood Road was coming up at this meeting. And so I was able to actually locate the PowerPoint from the League of California Cities that they just did earlier this year in March. I know some folks were able to go to that academy, and I'm not sure if any of the members present went to this presentation. I'm not going to go to in as much depth as they do, even in the PowerPoint slides. There's a lot of information in here and a lot of good links to resources at the end. So with that, we'll go ahead and move into it. And so Ms. Armour, if you please, next slide. This is just a presentation overview. We'll go ahead and go on to the next slide, Ms. Armour. So this is a little bit of history on CEQA. It was enacted in 1970. It was based on the Environmental Bill of Rights. The federal counterpart is the National Environmental Policy Act, NEPA is how that is. That's the acronym that we use for that. Originally, CEQA was actually only implemented at the state agency level, but in 1972, there was a court case that changed that. So now it is implemented at the local agency level. There's always amendments to CEQA, whether that's based on legislative action, court decisions, and local jurisdictions can actually create their own guidelines and thresholds. Many jurisdictions don't do that. The town does not have their own CEQA guidelines. So we follow the state guidelines for CEQA. Next slide. Let's what are we trying to get to here? And I've mentioned this at the last meeting. It really is just an informational disclosure document so that the public and decision makers are aware of the environmental effects of a potential project. And ultimately to try to solve any of the impacts from that project through ultimately mitigation measures if possible. And then ultimately, if there are impacts which are significant and unavoidable, a jurisdiction can still consider that project, and if they choose, can ultimately approve that project, and they just would adopt overriding considerations and findings for that. Next slide. This is just a list of key terms. I'm not going to go through all of these. I know you all have probably had a chance to read through this. So next slide, Ms. Armour. So CEQA is really looking at what changes or impacts are going to occur from the proposed project. And it's really changes from existing conditions. And there's some additional comments towards the end of this PowerPoint, but it's not to fix existing problems. I know this has come up in the past on a number of projects where we have an existing, let's just use beach traffic as an example. We have an existing problem. That's not the project's fault, and they don't have to mitigate that problem. They just have to mitigate from the baseline conditions to what impacts their project would have. Looks at short and long-term, direct and indirect impacts, cumulative changes, and then also local and regional plans, whether that's town code. We see it sometimes for hillside subdivisions. You'll have references potentially to the hillside development standards and guidelines if there are portions of that it doesn't meet, town code, things of that nature. Next slide, Ms. Armour. This is just a list of the players. I don't think any of these would be too out of the ordinary as far as the Planning Commission. The only one maybe is responsible agency, and I can't remember if they define that in the terms, but ultimately the responsible agencies would be outside agencies, such as Caltrans or Department of Fish and Wildlife. Those are the ones we generally hear from on projects, depending on the scope of that project. Next slide. So first, we got to figure out whether or not we have a discretionary project, because CEQA only applies to discretionary projects. And so, it's the entirety of the action, as this slide states, that could result in potentially direct or reasonably foreseeable indirect physical change in the environment. Next slide. So we have a project. Now we have to figure out what we have to do. There's generally, as listed here, 3 basic outcomes. The project could be exempt from CEQA. There are a number of statutory and categorical exemptions that are contained in CEQA. And those are the types of projects the Planning Commission mostly sees is projects that are categorically exempt, specifically with conditional use permits and single family homes in general. Next would be a negative declaration or mitigated negative declaration. I'll talk a little bit about this further into the PowerPoint, but basically in my time with the town, I've only seen one negative declaration, and the difference is there's nothing that needs to be mitigated. So there's no mitigation measures. Once you have mitigation measures, then you get into the mitigated negative declaration. And then lastly would be an environmental impact report, or EIR. Next slide. So this slide, I don't know exactly what they were trying to get at, but my assumption is that the town actually makes the determination whether a project is exempt from CEQA. And so, we have a lot of authority from a staff perspective on that front. And so, we generally go through, and if it's not obviously statutorily or categorically exempt, then we will reach out to our consultants. The town uses outside consultants to prepare our environmental documents. And so we reach out to them and get their guidance as well if we're unsure, as well as obviously in coordination with the town attorney. Next slide. So here's how are they made. Again, this is a determination that's ultimately made by myself in consultation with the town attorney sometimes. Most of them are pretty obvious what the path is. Then it's really up to the applicant ultimately to decide whether they want to go to the preparation of a mitigated negative declaration or go straight to an EIR, even though it may not be necessary. So this lists the number of items that are considered while making that determination. Next slide. So this one is speaking to the preparation of an EIR, even though a mitigating negative declaration isn't necessary. And so that's ultimately the applicant's decision to weigh kind of the cost benefit analysis on that. And just quickly, someone could choose to do a mitigating negative declaration, go through that process, and we'll talk a little bit more about substantial evidence and fair argument down the line, but they need to weigh the cost and potential time of doing an MND versus the need to potentially, if it's challenged, have to do an EIR, which basically starts the whole process all over again. And as mentioned, it is generally more expensive, although that gap is somewhat decreasing because the mitigated negative declarations generally have to do all the same technical studies. There's just a little more work that has to be done from an EIR perspective. So thank you. So this talks a little bit about ministerial versus discretionary projects. So for instance, ministerial projects are, sign permits, building permits. So those are automatically exempt from CEQA generally. And so, because building permits never have any public input, those are ministerial in nature. You see discretionary projects all the time for the town, which isn't the case in all jurisdictions. Single family homes are discretionary review. Second story additions are discretionary review, whereas other jurisdictions, those are actually ministerial and they're just done through a building permit. Next slide. So this slide really lays out the fair argument standard. And as this slide states, it's purposely a low threshold. And so ultimately, if someone does an MND, and we've had this happen numerous times in town, well, I shouldn't say numerous. We've had this happen a couple times in town since I've been here, where someone went through the mitigating negative declaration process. A lawsuit was filed ultimately after the decision was rendered by either planning commission or town council. And then the courts required an environmental impact report to be produced for that project. And it had to go back through not only the environmental review process, but then the approval process as well. So this lists out some just ways you can get to the fair argument standard. Next slide. And this is the substantial evidence, which is the threshold for environmental impact reports. So this one actually requires that, after you examine the whole record, that there is a fair argument, which isn't necessarily, and I would look to the town attorney, but ultimately that there is evidence presented that a different conclusion could be reached other than what the conclusion was in the environmental impact report. And as it lists in B, this is straight from the code, from state code, or actually CEQA. Next slide. So this lists what substantial evidence is, facts, reasonable assumptions based on facts, and then expert opinion supported by facts. So again, it really boils down to facts. What it isn't, it's not an argument, it's not a speculation, it's not substantiated opinion or narrative, which I think you've heard the town attorney say many times as we review projects with environmental documents, and clearly inaccurate or erroneous information or socioeconomic impact that is not linked to a physical environmental impact. Next slide. This again talks about the CEQA documents, and which documents have the substantial evidence threshold and fair argument. Again, it's generally exemptions, environmental impact reports, and the addendums to environmental impact reports. And fair argument is the negative declarations. So either a negative declaration or a mitigated negative declaration and an addendum to a negative declaration. So this is a list of the different types of exemptions. Again, statutory, categorical, and general. The general one gets used a fair amount for some of our projects, or for instance, I'm trying to think of one. No, that one was not a project. So if basically reasonably, it's not going to result in any direct or reasonably foreseeable indirect physical change to the environment. And so they call this the common sense exemption. Next slide. This is speaking to negative versus mitigated. Really, the only distinction is whether or not it has mitigation measures or impacts that have to be mitigated. Next slide. This EIR. There's different types, obviously. They almost all follow the same basic format. So, generally, I'll just go through quickly. We receive a project, we determine an environmental impact has to be prepared. If that is the case, then we ask our consultants to provide a scope and cost for the preparation of the EIR. And this is the same as a mitigated negative declaration. We do the same thing on that front. Once we have a contract with them, then we prepare what's called a notice of preparation for an EIR, which is basically alerting the public that we're going to be preparing an EIR and we're the lead agency for a project, and that gets circulated for 30 days. Then during that period, we actually have what's called a scoping meeting. So that is an opportunity for members of the public to provide comments to staff and the consultants on what items they think should be addressed in the EIR. I will say probably less than a handful of items that aren't already studied have been brought up over the years in scoping meetings. And it really gets to maybe some specific issue that staff or the consultants weren't aware of. But otherwise, the EIRs are very thorough and study a broad range of topics. So following that scoping meeting, then the actual environmental impact report gets prepared by the consultants. Staff reviews that. They do all of the technical analysis, and then we release what's called a notice of completion. So once the notice of completion, we're informing the public that the EIR is complete and we are releasing it as the draft EIR. Next step is what we did this evening for the item before, which is holding a public hearing within the 45-day window for that notice of completion for folks to provide verbal comments. And then all of that gets packaged up, and all written or verbal comments that are received are responded to in what we call a final EIR. So that's packaged up together in conjunction with the draft EIR. And sometimes the comments that are made necessitate modifications to the EIR. So those are captured in the final EIR. All that's packaged up with the actual permit application information, then brought forward to the Planning Commission. And many times Planning Commission is just a recommending body to Town Council, but there are projects that might have an EIR that the Planning Commission could ultimately act on. So you may be the ones certifying that. That's pretty rare here in the town. Next slide. So here, there's again referencing every community has different standards. Again, from a baseline threshold perspective, the town does have some. Our most prominent one is no longer valid from a CEQA perspective, which was our level of service relating to traffic. That's no longer a valid CEQA argument. We still potentially can use that argument from a project perspective, but from a CEQA perspective, vehicle miles traveled is now the standard, and that has its own thresholds. And then there are other thresholds across other agencies. Bay Area Air Quality Management District has a number of those. Sometimes we get threshold comments from Caltrans. So we work through those and deal with that. As I mentioned before, some jurisdictions do have their own CEQA standards and guidelines. The town does not. Again, this is threshold of significance, detailing what that is. Ultimately, it's an identifiable quantitative, qualitative, or performance level of particular environmental effect. So again, this is getting back to what you guys have been hearing a lot, is whether it's objective standards, things like that, where it's really this is something that most of the time there is one outcome. Not that other folks might not have different interpretations of what that is. And I think town attorneys also talked about the reasonable person standard. And so sometimes that is used. But ultimately, we have thresholds. The guidelines obviously contain thresholds, general plan, municipal code, and then some of our other policy documents and development standards. So those would be addressed through that. And if there are any quantifiable, qualitative standards then that are related to environmental effects, then those have to be addressed. Next slide. So this is a little graphic on thresholds. So you see the dotted line in the middle is the threshold of significance. So you've got a proposed action that may have significant impacts, but once you add the mitigation measures, you can, in many cases, bring that level of significance down to a less than significant impact level, which would be below that threshold of significance. Next slide. This lists out what mitigation measures are intended to deal with. We won't go into detail on that. Next slide. This is similar, related to the previous slide. Next slide. So public comments. Obviously, tonight we didn't have any public comments. I'm not sure if we've received written comments. Sometimes it gets to be challenging because these are very lengthy, complicated documents. And for the public, sometimes to read through those can be very difficult. More often than not, the comments we receive are really based on the project, not actual CEQA thresholds, but nonetheless, we still address those in the final EIR. But ultimately, the whole point is to inform the public and decision makers of potential significant impacts. So we want as much public participation as we can get. Ultimately, most folks wait until we get to that decision level point here in the town. But ultimately, most of these comments that we receive are based on the project itself, not necessarily the CEQA document. Next slide. So this is where you guys come in. So if you have the authority to approve a project with either a mitigated negative declaration or an EIR, the CEQA is not done until the project's approved and the environmental document. For an M&D, we call it adopted. For an EIR, we call it certified. You're kind of the last set of eyes before the ultimate decision is made. And this is something that we mention often. If you have questions about whether it's environmental documents or projects, it always is helpful to let staff know if you have those questions, because oftentimes that's information that actually would be very beneficial to the rest of the commission and the public as well. And so oftentimes we'll sometimes package those up in desk items or addendums to be provided to the commission and available to the public. And the last note on this slide is adding your reasoning for the approval and or certification to the record, so that if it is challenged, there is a solid record for which the court decision would be based on. Next slide. So they have a list of myths. I don't agree with all of them, so we'll walk through those. The EIR will stop the project. That is not true. It's really, again, just a disclosure document. It's going to tell you how to vote on the project. That is true. That is not going to happen. It would be more expensive than a mitigated negative declaration. That's not a myth in our experience here at the town. It may be in some other jurisdictions, and actually some other jurisdictions prepare the environmental documents themselves. They don't use outside consultants. And I'm not sure if it's still the case, but in Southern California, the applicant actually hires the consultant and pays them. So they prepare it. Here, we receive the funds and we manage the environmental consultant. The next is longer than a mitigated negative declaration. It is technically longer from the review periods. There's no notice of preparation for a mitigated negative declaration. The review period is generally 20 or 30 days, not the 45 days. So it is generally a longer process, but it's not, as long as it has been in the past. So again, like the cost, that gap is starting to shrink a little bit. And it's definitely, as they state here next, definitely will be more thorough than a mitigated negative declaration. They all do the same studies. So that's often a myth. The biggest difference that you will notice in an EIR is that you have to provide alternatives. And as I think I mentioned last meeting, the alternatives have to show that they would have a reduced impact from what the proposed project is, but also meet the applicant's project objectives. And so that gets to be challenging when you've got an EIR for a project that actually didn't need to do an EIR, and a mitigated negative declaration would have sufficed, which does not have that alternatives analysis. But ultimately the applicant chose to do the EIR. So that's been something that the existing commissioners and council members have struggled with from time to time. Doesn't mean that the planning commission and or council can't choose one of those less impactful projects. And that was some of the basis for the decision on the Alberta Way, ultimately, when that got to the town council. And then lastly, that the EIR will be bulletproof. It's definitely more bulletproof than a mitigated negative declaration, but there's no perfect document in every case, and litigation, unfortunately, in not only the town, but the state, obviously, is fairly simple. So that in and of itself, even if let's say a neighbor or a group of neighbors file a court case, you still have to go through that whole process of going through the court until they render a decision. But that's, again, still time lost and ultimately money to pay their attorneys. We actually require, if litigation is proposed, we actually require the applicant to provide either the legal counsel or attorneys, or hire their own attorneys to handle that portion in most instances. Next slide. This is just a list of what it isn't. I think most of these are probably pretty evident. Next slide. This is just kind of a wrap up. CEQA evaluates how the project changes the environment. It's obviously circulated for public review. And if it is above the threshold, then you have to either adopt mitigation measures or make findings and overriding considerations, as I mentioned before. Next slide. So this is a list of some things that they're saying are coming. The vehicle miles traveled is here. We still haven't adopted our local vehicle miles traveled policy and potentially implementation guidance, but our colleagues over in Parks and Public Works are dealing with that. And so they're working with an outside consultant to get that going. As we've talked about multiple times, this is talking about taking away local authority. So the discretionary approval for some projects is being removed. And so the simplest one is accessory dwelling units. Up until, gosh, I want to say about 4 years ago, this ADUs were actually, for the town, we actually had discretion over those. Now, since the state law, I think the first big changes were in 2017 in this most recent batch, and actually was even probably before that when they become non-discretionary. But the state specifically said you can't have discretionary review for those objective standards we talked about a number of times. There's some infill exemptions that actually allow really big projects in certain instances to be exempt from EIRs. So you're going to see an increased use of addendums. We generally will probably use an addendum potentially, if it's even necessary at all, for our housing element, because that will be adopted after the general plan EIR will be certified, hopefully. And then they're peeling away not only local authority, but they're adding every year. They add projects that are either statutorily exempt is where we see changes most of the time by the legislature. Next slide. This is just three areas where you can get additional information. Next slide. Next slide. All right, that looks like that is it. So sorry for the lengthy PowerPoint and commentary. Rob, would you like to do your 73 slide PowerPoint now?
I took one out. It's only 72.
So great.
Excellent.
With that, we're available for any questions.
Thank you for that. That was very informative. Even if we had seen that presentation during the planning commissioners training, it's great to hear it and given from the perspective of the town, and just a few examples in there are very helpful. I did have one question, and that is, since when we see this next, it will be the final EIR that we will be certifying or recommending to the council for certification. If we individually have comments that we would like to make regarding the draft EIR, would those be provided to staff just like we were a member of the public, or is there anything special that we need to do if planning commissioners wanted to make comments on the DEIR?
Well, I'll defer to the town attorney, but I would say you could either submit them as a member of the public, or you can provide those as a planning commissioner as this comes forward.
So when we see the EIR next, it's still a draft EIR, and we can provide comments during that time, and then those will be responded to, and then do we see the EIR again, or does that just go forward with those?
So the comments, if you, let's just say, for instance, you're a member of the public. We have this 45-day window currently open. You and or the public will make comments. Those will be responded to in the final EIR. No additional comments are responded to after that, other than sometimes we will have errata sheets if it's something that we really truly think is an environmental issue that was missed by the consultant staff or members of the public. And so sometimes we'll do an errata. It will not go back through any circulation generally. And then it will be part of your recommendation going forward to town council.
Yeah, and so what I would say to the planning commission is, if you have any comments on this DEIR or any others in the future, is please try to get those comments in as part of this 45-day period, so we can see them and they can be responded to. I think that seems the best way to handle it. Then there's no surprise for staff or the other commissioners.
And through the chair, I would just suggest if folks do want to submit comments, you can always reach out to the town attorney or I as well to get further guidance on what that might look like and whether it's something that really needs to be done in that 45 days or something that you can comment on once we get to the actual decision-making process for the project and the environmental impact report.
All right, great, thank you. Any other comments or questions for staff from commissioners? I don't see, yeah, Commissioner Thomas.
I just had one comment or question. If we are going to submit any comments as a member of the public, should we avoid discussing the DEIR with other commissioners to avoid a Brown Act violation? Or if we're acting as members of the public, is it okay if we discuss?
So it'd be okay to submit those comments because those
Okay.
comments are also public and available to all the public.
Okay.
So in that sense, those are just public comments that you are submitting as a member of the public and don't count towards any Brown Act issues.
Thank you. And then I did also have a question about the consent calendar, but I can hold, I mean, just about how far in advance we'll be receiving the changes, the amendments to chapter 29 for the tree protection, how far in advance of that meeting we think we'll be getting that.
The changes aren't that involved. They primarily have to do with enforcement issues.
Okay.
And it's just a cleanup, but I'll try to get them as soon as I can.
Okay.
Been a crazy
no
summer.
rush. I just was wondering if it was going to be like a big thing that I needed to,
No,
I just
no,
wanted
no,
to have it on my
it's-
calendar, but
It's
if it's.
strategic strikes primarily with the problems that I see in it. And though I do want to get you early so that you might find other issues, but the primary issue since it's been adopted is that there's just not enough teeth in the enforcement part of it. So I'm trying to clean that up so that there can be more in fines and consequences to those that violate it. In certain areas where it's willful and knowledgeable as opposed to just innocent, trimming a tree.
Okay. Okay. Thank you. Thank you. Thank you.
Thank you, Director Paulson.
And to Commissioner Thomas, so whether it's 1,000 pages or 3, it's generally coming out the Friday before the meeting. We actually went through a very extensive update a couple of years ago on the tree preservation ordinance. So as the town attorney mentioned, this is really some strategic strikes. But I think during COVID, we did get a planning commission meeting agenda out the day before on Thursday instead of Friday once. So we try to do that, and if we can do it, we may send it under a separate cover, like we do with the environmental impact report. We say, hey, we've got this environmental impact report, and we try to give you more far in advance, more time, so that you can read through those documents.
Thank you. It's like the week that I go back to school. So I'm like, want to make sure that I'm not just receiving it, something that I care a lot about, making sure that everything's up to date and good. So thank you. I appreciate that.
All right, thank you for that question. Any other questions for staff? All right, so let's move on then to the report from the Director of Community Development.
Thank you. A couple things I wanted to announce. On June 29th, we'll be holding a public workshop on the general plan. The general plan was released to the public last Friday, I believe. And so we're going to hold a workshop to kind of walk through some of the changes. There actually will be a newsletter as well that will be published. And Ms. Armour is graciously volunteered to set up a table at the farmers market this weekend. So she'll be there with that newsletter and to help answer questions and point folks to that workshop. So if you know folks who are interested, definitely want to get them involved as early as possible. And then we're going to be looking for other outreach opportunities to really get the word out as much as possible over the summer in advance of the Planning Commission's consideration of the release of the environmental impact report, and then the Planning Commission's consideration of the draft general plan and EIR. And then secondly, I just wanted to mention that last council meeting, the council did authorize the town manager to execute an agreement with a consultant for our housing element. So we will be moving forward with that effort here shortly. We'll probably have a kickoff meeting with them as staff sometime in mid-July. And then we will be taking an action to the council in August to have them set up what's called our housing element update advisory board, which we call the HEAB, which is a really unfortunate acronym, but that's what we used last time as well. So we'll be starting that process, and that will be another opportunity to kind of get out there what we've been trying to get out there over the general plan update is that, hey, we need to produce, over 3 times or have the plans in place from a ordinance and general plan perspective to show that we can have an opportunity for developers to build this almost 2,000 units over the next 8-year cycle. So we want to definitely get that out there for folks. We're gonna outreach to some other groups. I know I'm going to try to talk to Rob. He's very in tune with the democracy tent folks, and so we want to get out in front of them. And if there's any other groups that you're aware of that you would like us to speak to, please let us know. You can just shoot me an email, and we'll do what we can to get that outreach done as well. And that concludes my report.
Well, thank you for that. A question for you regarding the upcoming meeting on the 29th, or even this weekend for the table that Ms. Armour is hosting. Are you looking for or expecting support from any of the General Plan Advisory Committee members?
So for farmers market, I don't believe we need any. And we're really going to be kind of laying out, and you'll see when the newsletter is released. It's going to kind of follow the same format of what changed and goes through elements and what's changed. The biggest change really is the housing component, and then the community place districts. Those are kind of the 2 big changes, but they really go together. But at this point, I don't think we need any GPAC input on those. I will be reaching out on the housing element to see if the 3 public members from the GPAC are interested in participating on the housing element update advisory board. And if not, we'll have to have the council appoint some new folks. But other than that, it's really just whether it's planning commissioners with your planning commission hat, or GPC or GPAC hat. As you talk to folks, just let them know. We need to. What I'm always concerned about, which happens almost every time, is we get to the planning commission, and this is the first time I've heard about it, and you've got a council chambers filled, or a Zoom attendee list filled with folks wondering how we got to this point, not understanding that we had 35 meetings with the GPAC, numerous workshops and meetings with planning commission councils and council planning commission joint study sessions. And so it's unfortunate, but this is how kind of this policy document development goes in a lot of cases. But the more that you folks, and then the town through all of our social media outlets and other avenues, just getting the word out to folks to pay attention. I know I've had numerous conversations with some folks who are unhappy with some just single family development that has happened. And so, every time I talk to someone who's interested in the process, I always point them to the website, losgatos2040.com. So there they can look at any of the documents, including the draft general plan. And then ultimately, I can't remember, Ms. Armour, if the newsletter is on there yet or not, but those documents, and kind of watch the progress and next steps of this general plan update.
All right, thank you. So now we move on to committee reports. In addition to their service on the Planning Commission, commissioners serve on a number of town committees. Are there any reports tonight from CEDAC or Historic Preservation?
No report from CEDAC.
And Commissioner Suzuki, I don't think I've seen HPC meet, but just wanted to verify.
I was present in the later half of the meeting. I couldn't attend the first half. Sorry, I'm a little bit sick. It's kind of hard for me to talk right now. So
Okay, sorry about that. Why don't we plan to hear from Historic Preservation at our next meeting? We can do a catch up then. Okay, great. Well, thank you very much for your attendance and for sitting through this education, and thank you staff for providing it. It's very, very helpful. And hopefully we'll continue to offer more of that. And if there's anything in particular commissioners would like to know and to have staff present, please let us know or let staff know. And we can make that happen to make sure that you're as educated as we can help you become. All right, thank you for that. And with that, this meeting is adjourned.